So to wrap up the deeds and transfer of title section, of course, we are repeating some of these terms just because they're things that you could potentially see on the test. I told you, when you record the deed, and I told you recording means you have taken it to the place called the Register of Deeds and the county that the property is located in, and you put it in there. That's what we call constructive notice. You are letting the public know that the ownership has changed, right? That's why we call it public record. If you want to know who owns this, there's this premise that you could go look it up. And I told you, if you look up the current owner of record, they are presumed to be the actual owner. It's not a guarantee for obvious reasons, right? Because it doesn't have to be recorded, but more than likely they are the owner. Now you'll see it in a future slide as well. Taking possession of the property is considered actual notice, right? So recording it, constructive notice, that somebody could figure out who probably owns it. Taking possession of the property is actual notice. Hey, you're there, you're the owner of record. That's pretty good evidence that you are the owner. If you are both occupying it and if you look at the Register of Deeds, it says you own it. Now just be very careful. That this is an example of how dangerous these test questions are. Take it with a grain of salt because, as I said, there's not a lot of them. But if you look at this question, it says, which of the following is required for a deed to be enforceable and legally binding on the parties to a sales contract for the purchase of vacant land in Raleigh? So we're just asking for it to be enforceable on the two parties, not enforceable against third-party claims and others. And so you got to be very careful because what they're really looking for is what's required for this deed to be valid, even though they use that dangerous word enforceable. And I don't want you to attempt to answer this one because I told you, I'm just showing you how dangerous these, yeah, there you go, Brooks, how dangerous this question is. Because it's just talking about the parties, not anybody else, not other claims. And so the only one of these that is required for it to be valid has to be signed by the grantor, and you have to be delivered and voluntarily accepted. In other words, one. Just be careful. These questions are slippery slopes. You got to make sure you pay attention to them. Now, I already mentioned this concept earlier as well. Pure race state is what North Carolina is and some other states. That just means first in line, first in right. If you record a lien first, it's typically paid out first. If you record a deed first, you are presumed to be the owner versus somebody else, which is why recordation is something we do in every real estate transaction, bar none, because we don't want there to be any risk of somebody going and recording a superior deed before you get a chance to. So recordation, first come, first serve. Same thing with the liens, as I said. Of course, liens have special priority because while most are first come, first serve, what two types of liens did we talk about? Specific liens that are always paid out first are the highest priority liens. Real property tax liens and there you go. Special assessments. Real property tax liens and special assessments. They beat out everything else no matter when they were recorded. Everything else is in order of recordation except for mechanics liens, which have that special rule that they're recorded sometime within 120 days of finishing work, but they backdate to the day that work was started or materials were dropped off. Kind of a special thing. Now, as you might imagine, folks, as I'm sitting here talking to you about these really interesting deed concepts and these transfer of title concepts and how it doesn't have to be recorded, because of that legal premise that it doesn't have to be recorded, it is not that uncommon for there to be what we call clouds on title. That is just a fancy way of saying there's some questions of ownership. It's not clear, it's uncertain, there's some reason why we're not sure. And this could be something like that story we talked about last week where the lady went to Raleigh and recorded a deed on the property that she had no right to. That could be a cloud on title because now there's this falsified document saying she had some ownership. It could be where somebody didn't sign as a grantor even though they were supposed to. Sometimes it could be something as trivial as a lien wasn't recorded either, right? Or it wasn't satisfied. So we're going to talk about that more later. But what happens is if you owe the bank $200,000 and you sell your house, the attorney is going to send a check to $200,000 to the bank. And the bank has to record what's called a deed reconveyance, or a satisfaction of the deed of trust, basically stating that, well, hey, we had the right to go after this property because of the money they owed us, this lien, but because they paid us, we no longer have that right. Well, as you might imagine, sometimes banks forget. As crazy as that sounds, banks forget to record that document that states, oh yeah, we don't have a claim against us anymore. That could be a cloud on title as well, because now there's liens on the property that need to be resolved, and they haven't yet. And so we've got to do some digging. There's a lot of things that can cause a cloud on title. When you're buying a property, when it's being transferred to you, you want to have what we call clear, marketable title. It means there's no clouds, there's no issues, there's no questions of validity. We like easy, clean, nice, simple, transferable. Now, if there are these issues, or if somebody else has a claim, or anything like that, they will do what they call a suit to quiet title. We'll talk about that several times. And it has to meet certain criteria in municipalities. You have to put it out in public notice. There's this cloud on title for this property. Please come forward if you think you have any claim of ownership. Please be prepared to prove your claim of ownership, defend your title, whatever. And so this title concept that we're stating is this concept, if you're said to hold title, that you could prove you're the owner. That's what you can do, right? When you're said to hold title, you can prove you're the owner. But sometimes it's not that easy. So anytime there are problems, defects, or things, we call those clouds on title, title defects, whatever you want to call it. And for a standard real estate transaction, these all need to get resolved before we close. Nobody wants to take title to a property with this uncertainty of, do I actually own it? Does somebody own it more than I do? Did they have the right to give it to me? What you got, Bill?
So are you saying that if you have clouds on title, that you can still close?
You can, if all parties agree to it.
Okay. Thank you.
It's not something that most people, especially if they're paying money for it, that most people are going to be willing to do, but it is legally possible. Now, you may or may not be able to get a title insurance policy on it. You may not have any additional coverages. You may be, opening yourself up to liability, but legally you could. Yeah.
Thank you.
Yeah. So we've been talking about deeds, and remember I told you, title is a concept of ownership. You are said to hold title, but in real estate land, there is no physical title, right? This concept. So the document, the physical document that we've been talking about this entire section is deeds. Deeds show the transfer of title. And so the purpose of a deed is to transfer ownership. And understand there are a lot of different types of deeds. And when we're dealing with... Now, let me clarify something. There are some very unique ones that technically do something a little different than transferring ownership, but the vast majority of them transfer ownership, transfer title. And the ones that do this, they all do it equally well. There is no good, better, or best deed in the sense of transferring title. They all transfer it. However, there is good, better, or best protections for these deeds. Think of it as like warranties or guarantees, right? Somebody basically giving you some protection when they transfer this to you, when they sell it to you. But they all transfer title the same way. And so with that word warranty or guarantee, you will see there is a lot of different deeds that are potentially testable that you need to know about in this class. And some of these words are going to look familiar. So let me just show you the lineup. We've got quitclaim deeds, bargain and sale deeds, limited warranty deeds, general warranty deeds, and of course I told you there are some special ones out there called special purpose deeds. Now the ones that transfer title, they all do it equally well. And no matter which one you use, they will all transfer title. They will all extinguish your claim. They will all do something along those lines. And so the big differentiation is, well, to what extent are you protected? Notice how some of them have that word warranty in there. And I want you to think of it exactly like you would a warranty with anything else. If you go to Walmart or Target or Best Buy or anywhere like that, and you buy an electronic device, let's just use that as an example. What do they always ask you when you buy something electronic?
Do you want to purchase a warranty with it?
There you go. Do you want the extended warranty, right? Because everything electronic comes with some type of manufacturer's coverage, right? A year or two, and it'll cover certain things. But they always ask, well, do you want the additional protection plan or the additional warranty? Where it's like 5 years, and like even if you lose it or you break it or you do this, like we'll replace it. And arguably that's kind of a scam, but that's neither here nor there. But I want you to think about it kind of like that. There is your basic warranty on transfer of title, and sometimes there is this extended warranty, kind of your bumper to bumper warranty. Now, nobody panic. We're going to go down this list because I saw somebody kind of like perk up when I moved it away from here. We're going to talk about each of these. Now, arguably, the way that this list is set up, it's kind of like the lowest end of the totem pole at the top, and it works its way up, except for the special purpose. But I'm going to teach it the other way around. We're going to start at the top, and we're going to work our way down. So as I told you, they all, if they're transferring title deeds, they all transfer title the same, but they may have different warranties or protections. And so there is this interesting concept, right? And we're talking about title, this concept of ownership. And so when I say protections, I mean protections for your concept of ownership. What happens if you don't actually own it? What happens if somebody else has a claim? What happens if there's a mistake in the transfer? You know, that's what we're getting into. So let's start with the tippy top protection. So what we call a general warranty deed. Okay, general warranty deed. This one should be thought of as your bumper to bumper, full protection warranty. Now, it's got some really crazy words on here, okay? When you're given a general warranty deed, it says that you get these covenants when you get this. And so these covenants include covenant of season, covenant against encumbrances, covenant of quiet enjoyment, covenant of further assurance, and covenant of warranty forever. Now that's all well and good that I said that and read it to you, but let's actually talk about what they mean. It's legal jargon number one, but if I say covenant of season, it's S-E-I-S-I-N, not like season of steak. That's spelled differently. The covenant of season is the right to convey. So if I own the property and I have the right to sell it, gift it, will it, or convey it to you, when I transfer title to you, you also have the right to convey it to somebody else. That's the covenant of season. The right to convey it yourself. Now, I'm going to ask you something here. The second one says covenant against encumbrances. I want you to say that in your head a couple of times and tell me if you have a problem with that statement. Covenant against encumbrances. Bridge says encumbrances go with the land. Be careful, because not by definition, appurtenances go with the land. But what is an encumbrance? Some type of burden. So is it, there you go, Bray. Now we're getting somewhere. They can't stop all encumbrances. Because, folks, public land use controls and private land use controls are encumbrances. So, let me clarify this, Donna. Hold on a second. Donna's like, oh, you got this face, Donna. Oh, it's something about something different. It's not this?
No, I am confused, but I'm listening. Go ahead.
Okay. When I say covenant against encumbrances, it's not all encumbrances. What that really translates it to is covenant against encumbrances except those that have been disclosed to you. That's what it is. You cannot guarantee there's none, because the fact that you can't build a restaurant in your cul-de-sac as a public land use control, that's an encumbrance. The fact that your HOA says you can't have chickens, that's an encumbrance. So we're saying no encumbrances except those you are aware of. There's no hidden liens, there's no hidden easements, there's no things that we haven't told you. So that's what it means, right? It's not an absolute covenant. Covenant against encumbrances, except for those that have been disclosed to you. Covenant of quiet enjoyment, this kind of goes back to the deep sea. Remember when we talked about the bundle of legal rights with disposition, exclusion, enjoyment, possession, and control? This is that word enjoyment again. So when we say covenant of quiet enjoyment, it's not, well, you get to like the property. No, it's nobody can claim superior ownership to you. That's what quiet enjoyment means. Nobody's claim is stronger than yours. Nobody can come and say they own it more than you own it. That's the covenant of quiet enjoyment. Covenant of further assurance says there will be no issues. If there ever is, then we will fix it. Covenant of further assurance. If there's ever any issues to your title, I will fix it. And covenant of warranty forever. This is the interesting one. This warranty goes back so long as this property has existed. Covenant of warranty forever. And so, folks, I want you to think about this. Pieces of property have been conveyed sometimes hundreds of times by now. I mean, the United States has been around for some chunk of change. And so some properties may only have 5 or 6 conveyances. Some could have hundreds of conveyances. But what we're saying is, no matter how far back you go, I'll fix it. If there's a title issue anywhere in the transferences over forever, then we'll fix it. So as you might imagine, this is a pretty hefty claim, right? We're like, no, it's good. Now, as scary as this sounds, folks, this is the most common. And when we get into it later, when we're talking about transfer of title in North Carolina, our standardized contract that we use very often states that a seller is going to be transferring title to a buyer by way of a general warranty deed. This is the best one for the grantee to get because it gives the most protections. This is the one that puts the grantor in the greatest seat of liability. But it doesn't transfer title any different than the other ones. Title is transferred. It's just additional protections. What you got, Bill?
Does the title insurance, does that, I know it's for the grantee, but does that help the grantor out at all?
It depends. Sometimes what the title insurance policy covers is hunting down the grantor to go after them. It may or may not be the immediately preceding grantor, though, so it just depends. But basically, that's what the title insurance covers is, well, hey, if we didn't discover an issue and it comes up, you're not going to have to pay out of pocket to hire an attorney and go and file a suit to quiet title. We will hunt down the appropriate parties. We will file the suit to quiet title. We will try to fix this on our dime that we promised to do from your title insurance policy. And that may include, once again, going after the grantor if they made these promises to you and they didn't actually adhere to them. But it depends. So this... Go ahead. Go ahead.
Issues with maybe 2 or 3 grantors behind or past, then that's the person they would go and look for.
Yeah.
Like how much liability is the grantee assuming for other grantees or grantors?
Subjectively, I don't know. It really just depends on how bad the title defect is, who caused it, who missed it. It really just depends. This is kind of one of those squirrely topics out there, right? Yeah. Who just put their hand down? Somebody have a question?
It was me, but never mind.
Okay.
I read it.
Okay. So as I said, this general warranty deed transfers title, but it is, greatest protections for the grantee, greatest level of liability for the grantor, right? This bumper-to-bumper warranty. It's got, hey, it's good, it's yours, it's transferable, there's no issues, we'll fix them if there is, and goes, back for forever. So some states call it a full covenant and warranty deed or just a warranty deed, but we call it a general warranty deed, so you can see all those pieces of language there. So one step down from the general warranty deed, you have what we call a special warranty deed. And the special warranty deed is sometimes referred to also as a limited warranty deed. And so this is kind of like your standard warranty that comes with something, right? It's not protections for forever, but there are some protections. And so here's where things started to get a little interesting, okay? There is this warranty that the grantor has received title and legally own it, and that they are transferring that ownership to you. And then they also warranty that they have not done anything in the time that they have owned it to mess up the title. I want you to understand what that means. If they've owned the property for 20 years, what they're guaranteeing to you is, in the 20 years I've owned it, there are no title defects that I've caused, right? In that 20 years, I promise. If there's something that shows up from 15 years ago and it was my fault, I will fix that. But what they're not doing is going back forever, like the other one is. We're basically stating, you don't come after us for things before our time. That's not a me problem. And so this is usually associated with foreclosure. I'll tell you where this is even more common, folks. If you purchased a new construction home in North Carolina within the past 15 years, this is probably what you got. Builders almost will always give you a special or limited warranty deed. Why? Because they purchased this 300 acres and then they chopped it up into little pieces, recorded a new plat map, and they're conveying one piece to you. They're not going to state that they're going to cover anything from like Farmer Brown, who owned it for the past 120 years. They're only going to cover for the time they owned it, for what they did. So builders love to do this. Now here's another interesting thing, folks. I want you to think back, okay? Before I teach you this, I want you to think back so you keep these two thoughts separate. When we were talking about fee simple determinable, what is fee simple determinable?
With conditions.
Yeah, and what was specifically, like what, because remember we were talking about the broad category, but determinable is like the very specific category. What did this fee simple determinable estate say that you had to do?
Use the property for a specific bank.
There you go. Determinable said you had to use it for one specific use. Now here's where I'm going with this, folks. Remember when we had those conversations, I told you you can't give anything other than what you have. You remember this? So if you own a property, fee simple determinable says, Tara, you can only use this as a horse farm. Tara can sell it, she can will it, she can gift it, but the new owners can only ever use it as a horse farm. You agree? You got to separate this in your mind. When it comes to deeds, you can give a better deed than what you got. You're not giving different ownership. It's still, they all transfer title the same. But you can get the better deed than what you got. Here's what I mean. If you purchase a new construction home in North Carolina in the past 15 years, I guarantee you got a special warranty deed. If you then sold that home, I guarantee you sold it and you gave somebody a general warranty deed. You see what happened there? Because by default, the attorney is going to make you draft up a general warranty deed because that's what the standard forms in North Carolina state you're going to do as a seller. So you can give a better deed than what you have. You just can't give better ownership than what you have. What you got, Brooks?
So, with the special warranty deed on a new build home or a foreclosure, is it possible to request a general warranty deed instead of a special warranty deed, or is that up to the seller?
It is absolutely possible to request anything, right? The biggest thing in real estate is everything's negotiable. Most people don't know to ask for that. And at the end of the day, 95% of the time, it's not a super consequential thing, right? It's just like builders don't want to be on the hook for forever. Occasionally it's an issue, and that's why we have title insurance policies that kind of help protect and help go after and help, do. But you could, in theory, request one. Would they go for it? Maybe, maybe not, right? No. So I'll kind of give you the other insight into this bottom note as well. It says usually associated with a foreclosure. I told you builders are even more common, but what it means with a foreclosure, folks, I mentioned this earlier. A foreclosure, everybody thinks that, the bank takes your property. And I already explained that's not a foreclosure. A foreclosure is the banks forcing the sale of your property to get their money. And so understand that sometimes when they force the sale of it and it goes to auction, the banks will actually bid on the properties themselves. Why? To make sure that they get a decent amount of money. And so occasionally the banks will win the auction and then they get the property. They didn't want the property, they wanted the money. But they end up with a property, and this is what we call a bank-owned property. So if you ever seen somebody call a property REO owned, means real estate owned, but that's just a fancy word for the bank owns it. And so if the bank owns the property, they're going to hire a real estate agent to list the property for sale in a standard transaction. And they're only going to give you a special warranty deed, because what they're saying is, well, we just bought this at a foreclosure auction. We've not done anything that in the time that we've owned it as the bank to mess up title, and we swear to that. But we're not going to warranty anything before the time we owned it. So yet again, that's what it is. We have title, we're giving title to you, and we promise in the time that we have owned it, we've not messed up the title. That's a special warranty deed, also called a limited warranty deed.
When you say mess up the title, you mean like title defects, right? Like, as far as like who owns it and title clouds and all of that.
Yeah, like signing it away to somebody and the deed was never recorded, and so you don't actually own it anymore, and then they come and try to like lay their claim to it. That'd be a title defect. Borrowing money against it, and then that wasn't recorded, and there's a lien on the property that's not found in the public record, right? All of these things would be title defects. So when I say mess up the title, anything.
Yeah, so technically with this, somebody could still come and take your property. Because they're not covering it.
Nobody can just come and take your property. In theory, what this is stating is, if there's a title defect from prior to the time that the previous grantors owned it, that's not their problem. Doesn't mean that somebody can take the property, but you may be defending your title in court against somebody else because the other grantor has absolved themselves, right? So if they owned it for 15 years, there's a title defect from 20 years ago, that's between you and you, right? Because it was not caused by them. Yeah. So the next tier down is what we call a bargain and sale deed. Now you're going to love this one, okay? This one, there are no express warranties against encumbrances. There are no warranties for time in any way, shape, or form. All this really does is it says, well, hey, I'm pretty sure I own it, and I'm transferring that ownership to you. That's it. Say it again. I'm pretty sure I own it, and I'm transferring that ownership to you. I'm not saying the title's good. I'm not saying there's no title defects. I'm not saying I'm going to fix it. I'm not saying any of that. I'm pretty sure I own it, and I'm transferring the ownership to you. So let me give you an example of this, okay? Imagine that you got a phone call from some random attorney that your great-great-uncle, that you didn't even know you had, who lives in Wyoming, had a llama farm, and when he dies, he left his llama farm to you because you were the only next of kin he had. So yeah, you just inherited a llama farm from a great uncle you didn't know you had, and you've never been to Wyoming. Now listen, if you don't plan to move to Wyoming and take over a llama farm, then you're probably just going to call somebody and sell it. And so more than likely, if you sell this llama farm and take the money, you're going to give somebody a bargain and sale deed. Why? Because some attorney told you owned it. So here we go. I'm pretty sure I own it because some attorney told me I did, and I'm transferring that ownership to you. You don't even know if this is your great uncle. You never met the guy. You don't know how you ended up with it. So you're not going to make all these promises, warranties, or protections. I'm pretty sure I own it, and I'm transferring that ownership to you. That is a bargain and sale deed. Now, this last note here, you got to be very careful because they're very similar. It says very similar to a quitclaim deed, and so that's the next one. Now, I want you to hear the difference here, okay? I want you to see the language that I'm stating. I believe I own it. I'm pretty sure I own it, right? That's a critical piece of this bargain and sale deed. I've been told I own it. I think I own it. I'm pretty sure I own it, and I'm transferring that ownership to you. There is this implication of ownership that I do hold title. that is within a bargain and sale deed. And that's different when we get to the quitclaim deed. By the way, before I open up the quitclaim deed, where, folks, do you typically hear of quitclaim deeds being utilized? There you go. Divorce, very common in divorce and separations, flips too, potentially. So a quitclaim deed, I want you to think about the words there. Quit claim. You are quitting your claim. And so there is no warranties in this in any way, shape, or form. I don't know if I have any ownership or not, but if I do, it's yours. I'm going to say it again. I don't know if I have any ownership. I don't know if I have any claim, but if I do, it's yours. You see the difference? In the bargain and sale deed, I'm pretty sure I own it, and I'm transferring it to you. And this one, I don't know if I own it or not, but if I do, I'm transferring it to you. In other words, I am quitting my claim, and so this is why it comes up with divorce. Remember when we talked about a marital interest? If you own a property in severalty, and then you get married, and then, now there's this marital interest on the property. There's this claim on the property because you got married to this person. Well, this is how you fix it. Do they have half interest in your property? No. Do they potentially have some interest? Yeah. To what extent? We don't know. And so if you have them sign a quitclaim deed, then they are quitting their claim. That prevents a title defect. And so we don't know if you own it or not, but if you do, or if you have any interest, you are quitting your claim to it. Now, understand, though, that this transfers title just the same. I'll tell you a funny story, true story. My dad got remarried later in life, and him and his spouse owned a house in Clayton. And she was from California, and they were married for a while. And I think after a while, they ended up getting separated, divorced, I don't know. And she went back to California. And I, of course, being in real estate, had a conversation with my dad one time because he kept the house. And it was like a really weird scenario where I'm like, where apparently he was living there, he was paying the mortgage, but at some point, I don't know exactly what the legal ramifications were, he had signed a quitclaim deed, I guess when they got separated, quitting his claim back to her. And so there he was living in this house. He wasn't on the deed anymore. He wasn't on the mortgage, but he was paying everything. And I looked at him and said, Dad, that's not good. You're basically a tenant right now because it's all in her name. And he's like, oh, no, it's not a big deal. Like, she doesn't want the house. She doesn't care about the house. I said, well, God, I hope you're right. And so, I kind of gave him some advice, and he was looking at refinancing it. And he, turns out he was right. She didn't care about the house. So I want you to think about this. They had some type of deed, maybe tenancy by the entirety, maybe tenancy, I don't know. And he signed a quitclaim, removing himself from it. So then she looked like just the owner. And then what ultimately ended up happening is she signed a quitclaim deed back to him. So there was this one deed, a quitclaim, and then another quitclaim. And even as low on the totem pole as this quitclaim is, where it says, I don't know if I own it or not, there's no question that my dad owns this property now. Because if you look, there's a quitclaim deed where the previous grantor has quit their claim in its entirety. Did she need to do a quitclaim deed? No. But she just didn't want any liabilities whatsoever for that property. So that's what she gave him. That's what he has. Now, yet again, I told you when we're dealing with deeds, you can give a better one than what you have. So if my dad ever goes to sell that property, he will give the next person a general warranty deed. He's been there for 25 years. He's not really worried about any clouds on title. So you can always give better than what you have. But quitclaim deed, I don't know if I own it or not. Whatever I do or don't own, I'm quitting my claim. It's yours. I'm signing it away. Typically used to cure a title defect. Now, there's a couple special purpose deeds, and this is where I said, not all deeds technically transfer title. Most do, but some of these do not. And so let me just start with this top one, folks, a correction deed. Let me reiterate what the Register of Deeds is. You go down, either digitally or in person, to a physical place at the county courthouse. You give somebody a document and you say, record this. And they basically add it to these giant books so that somebody could come and find this information. Well, folks, it's not like a Word document. You can't delete things. There's no backspace. There is no whiteout. There's none of that. And so, as you might imagine, us being humans, there are times where somebody would record a deed and they typed the address wrong, or they spelled a name wrong, or they did something along these lines. You can't go in and fix that just by saying delete, delete, delete. It doesn't work that way. So you would record a new deed called a correction deed. So for example, let's say that, your last name was missing a letter. You would say, here's a correction deed. In regard to this previous deed that was recorded, the name was spelled this way. It should have been spelled this way. And that would show that you still own it, but we are correcting the spelling so there's no title defects in the future, that when you go to transfer it, that you are, in fact, the person who owns it. You can't delete stuff. It's called a correction deed. Now, going back to what the question was earlier, when we're dealing with title theory states versus lien theory states, if you get foreclosed upon in North Carolina, which is a title theory state, the ownership is transferred to the person who wins at the auction by way of a trustee's deed. Because I told you the trustee is the one holding that legal title that you transferred away. In the lien theory states where the seller, the owner, retains the legal title and they have to go through a court hearing, it's called a judicial foreclosure. Title is transferred by way of a sheriff's deed after the court hearing, and the foreclosure is finalized by way of this judicial foreclosure. Of course, deed of gift would be giving something without consideration, has to be recorded for certain periods of time. So we're going to talk about these, let me go back here, a little more in detail in the financing section, but here's just kind of an introduction to them. Corrections are only for administrative errors only. Yes. Correction deeds fix typos, typographical things, legal description errors, things like that. That's exactly right. So trustee's deed used to transfer title in a title theory state, which North Carolina is. And then a sheriff's deed used to transfer title in a lien theory state, which North Carolina is not, after a judicial foreclosure has been held. And then, of course, as I stated, there's a few others. And we kind of talked about this when we were dealing with appurtenances and, certain rights, like mineral, oil, and gas rights, timber rights. You can sever off rights to property. So your timber deed would transfer the rights to cut timber on the land. Your mineral right deed or gas right deed would give somebody the right to access the subsurface rights on a property. Could be one, could be both. Could be more specific, like lithium. The middle one here, the deed in lieu of foreclosure. This goes back to what I said about the banks, especially because, it is a little bit of a process, more so in judicial foreclosure states, but sometimes, as opposed to going through the foreclosure, the owner of the property will just sign the deed fully and completely over to the bank. So they don't even have to go through the foreclosure process, which just allows them to save the cost of the foreclosure. So sometimes it's just an easier thing for the owner to do. If they know there's an impending foreclosure, sometimes the lesser of two evils, they can just sign the deed over to the bank. What you got, Bill?
So for a timber deed or something like that, can you set time limits so it's good for 5 years, or once it's there, it's there?
You could, but that would really just be leasing the rights at that point. You wouldn't sign a deed. You would basically do a lease for mineral, oil, and gas rights or something like that. But now you would still record these leases. It's called a memorandum of lease for subsurface rights or timber rights. So they're still recorded, but you wouldn't use the deed because that's giving ownership, in perpetuity typically. Otherwise, it'd just be a memorandum of lease. Yep. So a lot of this stuff is just repeating, repetitious, as we said, because it is so unique. And so we talked about recording this public record, the Register of Deeds. I told you, first in line, first in right. First to record is, considered to be the owner. First lien gets paid first. That's kind of how this works, which is why we never don't record, because it would be very, very risky, dangerous, and otherwise. So we always record to protect ourselves per the Connor Act of any third parties, creditors, claimants, whoever they may be. And then I've also used this language as well. I told you, recording something acts as constructive notice. You are notifying the public that if they cared enough, they could look at the public record to figure out who the owner of record was. And the owner of record is I'm going to say it again, presumably the owner. There is no finite guarantee because of some of these quirky laws, but they're presumably the owner. And then I told you, if you are physically taking possession of the property after recording it, you are giving actual notice. It is a lot more likely that you are in fact the owner if you are the owner of record and you're occupying the property. Just pausing for dramatic effect. Jack, you get you one of them like $3 Long Island iced teas from Applebee's. Is that? Yeah, that's why we switched it up tonight. There you go. I was looking at it. I saw there was a different restaurant back there. Good old Applebee's. Get your blue motorcycle. We're almost done with this this deed stuff. I promise the next section is a little more straightforward. Let me just kind of touch on a few more notes here. We already talked about priority, first come, first serve. Of course, there are those special ones like the real property tax liens, which are a higher priority. And then, of course, special assessments, also a higher priority. But when we were talking about the Machinery Act and taxes, I told you in North Carolina, the tax lien is said to be on the property as of January 1. But I also explained to you that it's what's called an unrecorded document. Can you imagine the hundreds of thousands, if not way more than that, tax liens they would have to record against all the pieces of real estate in North Carolina? They don't do that. So it's an unrecorded document. It's said to be on there. We know that you owe the money, but they're not going to actually record it until it's considered past due or delinquent. And of course, you're not considered past due in your taxes until January 6th of the following year. So some of these start out as unrecorded until they're delinquent. So there's this other cool concept that comes into play when we're dealing with title, this concept of ownership. And so it's what we call chain of title, literally chain of title. And here's why. Right now, if you own a house, there is a deed where the previous owner is named as the grantor and you are named as the grantee. There should also be a deed that immediately precedes that where the grantor who gave it to you was the grantee on the previous deed. And then there should be one preceding that where that grantor was the grantee immediately prior. And so they all link together from this person to that person, that person to that person, that person to that person. That is called a chain of title. It looks like a literal chain because they all interlock and connect. And if there's ever a broken chain, if there's something not sure, if there's a missing name, that is also a title defect as well. And so we'd have to figure out why is there this issue in the chain of title. Now, here's a very testable North Carolina concept. In North Carolina, our title searches, which is where the attorneys will go back and look at the title and give an opinion of title, look at the chain of title. They go back 30 years and 30 years only, even though properties have been being conveyed for hundreds of years. And it's because of something called the North Carolina Marketable Title Act. What that basically states, if there is any claims that are older than 30, we have extinguished them. You've lost that claim to that property. Anything older than 30 sucks to suck, Chuck. So we only have to do a title search 30 years back. Because if there's a title defect from 40 years ago, we don't care. They will not hear it in court anymore. You don't have a claim to it anymore if it's 40 years old. So title searches in North Carolina go back 30 years. We left off talking about chain of title. And I told you, it's kind of this concept of these linked conveyances, right? This deed should link to that deed. This deed should link to that deed. So on and so forth. And this is what the attorney looks at whenever they are doing a title search, right? They're looking at liens, they're looking at conveyances, they're looking at a lot of different information. Folks, the Register of Deeds is public. Like any of us can look in the Register of Deeds. but only an attorney can give an opinion of title, can do a title search in that regard, right? We as real estate agents are not able to do that in any way, shape, or form. So when they're doing this title search, they are looking for a lot of different things. And this is kind of the list here, right? 5 criteria for marketable title. And I want to warn you of something here, folks. You see this word title assurance. It is assurance that there is good marketable title. Please do not confuse that with title insurance, okay? We were kind of talking, Bill and I were talking about insurance a minute ago, and so this is where some of these words can get very confusing, very dangerous, because they're not the same, but they kind of sound similar. So assurance of title, title assurance, in other words, being assured that the title is good and marketable. So free of significant liens and encumbrances. So some encumbrances are okay, but we don't want any significant ones. No serious defects, right? No questions of conveyances, no questions of, did this person get this under legal premise or not? No questions of law or fact that question its validity. Yet again, kind of goes hand in hand there. Did they steal it? Did they go through the appropriate motions? Has it been transferred under normal conveyances? Things of that nature. Promise of quiet enjoyment to grantee. Yet again, quiet enjoyment means nobody can claim superior title. The title is good to the extent that when it's given to the next person, there's nobody else who could go and fight them in court and prove they owned it more than they do. Now, the last one, just for clarity, it says, be reasonably assured of fair market value. Folks, the attorneys are not really looking at what's fair market value? What we mean is, does it have value? Can it be conveyed? And so if you imagine a piece of property that can't be sold, can't be conveyed, it has use, but it has no value, right? So can it be sold? Can it be conveyed in the future? And ergo, does it still have value? So these are the kind of criteria that the attorney is looking for to give this opinion of title, is what they call it, for this title assurance. Once again, not to be confused with title insurance, which we'll talk about more in just a second. And of course, promise I didn't freeze there. I have kids, and when I hear loud noise, I have to pause, and I'm like, is that a hospital loud noise, or is that just a kids being kids loud noise? You know what I'm saying? You just gotta kind of have that moment of so there's that. So when we're talking about this opinion of title as given by the attorney, right? This is where they will say, okay, yeah, we feel good that there's no major issues, no title defects, and that's what allows the title insurance company to issue a title insurance policy. As I said, we're going to talk about that. If there's any issues, most buyers aren't willing to take it on. Most grantees, if you will. I guess it's not always being bought. And so that's where, in order to be able to convey it, a lot of times we will have to clear any title defects. And that's what I told you is called that suit to quiet title, where we try to extinguish any claims that somebody may or may not have. Prove that you have a claim. Somebody else is going to prove that you don't. This would also be that adverse possession suit, right? If you were trying to steal property for somebody, the suit to quiet title would be you proving that you met the criteria of adverse possession and nobody else coming and saying that you didn't. So a lot of different ways this suit to quiet title can happen. They can be major, they can be small, but it is a legal and formal process to extinguish claims so that they don't exist anymore and it can be conveyed with clear title.